Andrew, thank you so much for being on board on this new session of Legal Notes that we have on YouTube.
Hello, I'm Andrew Yeates. I am trained as a lawyer, and I've worked all my career really in television, music and publishing, and with a particular interest in how rights are administered through collective management organisations.
Thank you so much for giving me the honour of interviewing you on something which I think is most important for us lawyers and producers, which is secondary rights. Now, as opposed to the primary rights that we should all know are those rights exclusively owned by the controller or who creates something which are artistic for the reproductions, what are secondary rights?
There are many different definitions, but I think I see them in two ways. There are the things which are additional to what you need to do as a primary purpose and where you'll be working with other people to deliver those. So they could be publishing rights, merchandising rights, versioning rights linked to the creation of a film. And the area that I'm most specialised in, which is what I call tertiary rights, which are the rights which are exercised through collective management organisations or with the assistance of independent management entities.
Now, how important are secondary rights for a producer in terms of monetizing? Is it worth for a producer to keep an eye on how they are dealt in a contract?
The definitions are very, very important. Think about what it is that you would like to do, but also think about how you're going to exercise those rights in a realistic way. That means understanding the obligations that you'll have to third parties for residual payments or additional payments if you exercise the secondary rights, and how you will work with collecting societies and independent management entities to assert the tertiary right, which should be exercised through a CMO and in accordance with CMO rules.
Now, we know that collecting societies are those by default, the authorities that have to monitor the market and collect for the authors or the copyright holders, whatever those royalties are. To your knowledge and experience, do they work properly? Is there a space that needs to be filled in by independent collectors?
There's often a feeling that CMOs are a bit of a mystery, and I think we do need to be as transparent as possible about this. The European Collective Management Directive that came out in 2014 set down standards by which CMOs should operate in Europe, and these have been good at actually shining light on the internal systems of CMOs, which should prove very helpful for lawyers. Now, proper distribution policies should be published. Transparency reports about what a CMO does and who they represent are also published by them. So it is worth looking out the name of the CMO, looking on the website and checking exactly what they do and how they do it.
Please give us an idea on how collecting of secondary rights work. You in a previous conversation with me, you talked about metadata. How do the metadata work?
When you're making a film, hopefully part of the production requirements will be to make sure that you get an ISAN registration number and you apply that to the film. Collective management organisations will use that sort of data to identify films going forwards, and there will be subsidiary, whether there's video ISAN numbers or subsidiary clip numbers applied to those films, which will be crucial in actually showing it is your film that's being used in a particular circumstance and which should trigger a payment through the CMO system.
Now, obviously there's piracy around, but there's also unlawful behavior on behalf of distributors and producers. I am, as a IFTA arbitrator, have gone through many of these issues. How can this be avoided? It's a technical barrier device, obviously, that makes it possible.
Yes, but on the other hand, the collective management organisations, who are, after all, usually given their authority through local national laws, will have an obligation to look at these things and check them out appropriately. There are dispute resolution processes operated by the CMOs. There are also now regulations to say that those things can't just be left hanging for years and years and years. They do need to be addressed in a timely way. So all those things help. In terms of dealing with piracy, then obviously it's important that people are aware of their local rights checking mechanisms, what authorities actually operate to try to identify where unauthorized use is taking place, and to work closely with them as well as the CMOs.
Now, Andrew, you also told me a little bit about the residual rights, which are an issue right now in the United States, are becoming an issue also here in Europe. How can a good regulation and a good contract drafting help these residuals to be at least dealt with properly?
Well, I think it's a question then again of having clauses and understanding where residual payments are supposed to come from and who is responsible for it. We're facing a world where, as we get increasingly into the online arena and with AI and other issues coming along, that you are being bumped down the order of rights holders. And so you've then got more and more people above you who are supposed to be reporting about how your rights have been used and how you can check that out. So the traditional audit and accounting clauses are incredibly important. The working with local bodies, whether it's local unions or other bodies who might have more clout than an individual producer, to actually demand that those audit provisions are properly checked and reported on, are going to become increasingly important.
So what would be your rule of thumb in advising lawyers and producers to have a look in drafting the contracts?
Make sure you understand the audit provisions and that they are realistic in terms of how they're going to be asserted. Because it's no good just putting in an audit clause in a contract with somebody who might then assign on all their rights to a third party and feel that they've got no obligation to you. So encourage the chain of title, if you like, for those audit provisions to be enforceable.
We also spoke a little bit about artificial intelligence. How is artificial intelligence generating copyrightable material dealt with secondary rights?
Think carefully about how you define artificial intelligence. It is technology, essentially, which is itself absolutely based on intellectual property rights. The algorithms that are being written are computer software programs. Those are literary works. Therefore, we have to look at exactly how those are then being licensed and whether there should be new regulation around the way that those are licensed. And if you simply put into your contract, I want AI rights, that will be questioned further down the line. But if unions representing performers and other groups start to say, no, there are certain things that you are not entitled to do without further permissions, use my face or the sound of the voice and so on, and adapt that and change that in a way that I would wish to have an opportunity to comment on. Those sort of clauses are going to be quite specific and can be built into contracts and hopefully be enforceable as we move forward.
Yes, because it's always a question of the right to copy, which is the Anglo-Saxon, I would say most the American traditional way of dealing with copyrightable material, intellectual property, and the European old continent way of approaching the right of the authors and the privacy of the authors to maintain control. It's still there, isn't it? Andrew, could you give us an example, sort of a case history of the three ways secondary rights are dealt and should be dealt with in audiovisual, movies, and recording, sound recording?
I suppose the audiovisual one, which I think is interesting, is the way that program versions can be made. Because if you have a format for a program that's been established and you want to try to permit versions to be made around the world on a syndicated basis or not, that is a good example of secondary rights where your contract terms will actually support the copyrights that you actually own, and you can spell out what it is you are prepared to allow people to do or not allow them to do. Where you're a sound recording producer, you end up with the master recording rights, but you don't necessarily have control over the music publishing rights. But nevertheless, there may be a mutually agreed opportunity for that recording to be used in a new feature film or in an advertisement in a way that everybody is happy with. And that would be a good exercise of secondary rights.
You also mentioned in a previous conversation the outcome of YouTube, and most possibly in the next few years, which will be most probably the new big streamer of the world. How is YouTube dealing with the secondary rights?
As an example of YouTube, it's helpful that there have been sensible negotiations between YouTube and, say, the music industry as to how music that is synchronized with user-generated content on YouTube is actually now licensed. That is a really good step forward because it again shows that collecting societies who are exercising rights on behalf of rights holders in cases where they practically can't exercise them themselves can step in. The CMO does the deal with YouTube, and hopefully your work is in the system and you may get some payment for its use. As far as professional broadcasters and others who decide to have their own specific channels on YouTube, as you know, those are like any other commercial negotiation. You agree the terms, and hopefully the broadcaster will still remain responsible for clearances to make sure that the online delivery can take place through this new technology.
Allow me to do a step back regarding residuals. Do you think there should be a disclosure of such algorithms? Because there is basically the measurement of the secondary rights and obviously the residuals.
Within the UK, there's been a very interesting debate about music streaming because there was a feeling by some contributors that they were not getting fairly remunerated for the streaming of their works on new streaming platforms. And it's shone a light to show that really, you only got a very small payment for, say, 1 million streams of your work. And as a result of that, there's been a reassessment, really, of how the shares of revenue may be looked at and what could be adjusted going forward. But that only works if there are sensible audit provisions for these streamers to actually show what they're doing.
I know a lot of huge companies are transitioning from the traditional making of movies into gaming. Now, is that a place where secondary rights can generate great revenues?
Yes, I'm too old to have got involved in the gaming side of things, but I think the AI technologies are certainly providing a huge opportunity for new things to come out of the audiovisual sector. But that said, I think it is also a time where industrial relations negotiators and representative bodies will have to look carefully about what is actually being licensed and where full stops have to be put before some things go ahead without checking with the rights holders and without reassuring them that what is going to happen is not unauthorized or indeed harmful to the public. So as far as an author is concerned or a well-known artist is concerned, there clearly are dangers that their face or their voice or their well-known phrases are used in a wrong context in a way that confuses the public and which actually makes them feel that they're being led into a particular safe area for their entertainment when they're not. There are arguments that there are fair use, but that's where, as lawyers and preparing the ground for where a work might be used, we need to set in some caveats so that those can be acted on as and when necessary. And fair use is meant to be fair, let's face it. There's always legal challenges in the States, but the underlying challenge for us all is that not everybody is a company of a size that can take on some of these large multinational platforms in litigation whenever something goes wrong. We need to have backup systems through things like collective management organisation and even union and industrial relations negotiations to help represent individual creators.
Well, thank you so much, Andrew. This was very, very useful for my personal knowledge and obviously for all the lawyers who are attached to the magazine of value, around 42,000 Italian law firms, and obviously producers and authors that look at the YouTube channel. Thank you so much, and I hope to see you soon again.
Thank you, Alberto. See you soon.